Thank you for clicking this video. This is Batok with Ola, and today we want to talk about Garnishee Proceedings. We mentioned it briefly when we were talking about enforcement of judgment in Nigeria. Please watch that video. It's a very long video, and I talked about the different means and ways of enforcing judgments, court judgments in Nigeria. And one of those methods is Garnishee Proceedings. Usually this deals with money. So when it's more appropriate for enforcing a judgment that's in a monetary sum, so we have the garnishee, the garnisher, and we have the judgment debtor. So we're going to be explaining them in this video. Please watch till the end, and don't forget to like the video and leave a comment in the comment section, and please by all means subscribe to the channel. What is Garnishee Proceedings? Garnishee Proceedings is the means by which a judgment creditor comes to court asking the court to give an order attaching the monies in the bank accounts of a judgment debtor with a bank that is usually called the garnishee. The judgment creditor becomes the garnisher in a garnishee proceeding, and then the bank that is housing the money belonging to a judgment debtor, that is a person that the court has awarded an amount against, that is supposed to pay an amount of money, a sum, in settlement of a judgment of the court. That's a judgment debtor. A judgment creditor is the person that wins a case or that wins a monetary sum against the other person in court. So they are the creditor because they are the ones or the one to whom that money falls due and to be paid to. So creditor, then debtor, the person that is supposed to pay the money, and then the bank that is housing the money, their own money, separate money. The bank is called a garnish. The bank is called a garnishee. So a garnisher will file garnishee proceedings by a motion ex parte, asking the court to make a decree, commanding the garnishee to release the monies, usually specified the sum, held by the bank or the garnishee, for their customer, the judgment debtor, to them, the creditor, the garnisher, in settlement of their judgment debt. I hope you understand it. So the garnishee is usually a third party, but now the creditor must have caught wind that, oh, this person that has refused to pay the judgment sum that they're supposed to pay to me, they have monies in so and so bank accounts. So I'm going to go to court and tell the court to make an order to compel their bank to release their sum to me, to release their money to me to the extent of the judgment debt, the judgment sum that they owe me. So that is essentially what garnishee is about. And of course we have the garnisher, the garnishee, and the judgment debtor. So three parts. So the garnishee is usually a third party. They don't know anything about what has happened between the creditor and the debtor, but they just come into play because the creditor now knows that the debtor has money with them. So instead of claiming that I don't have money, I don't want to pay you, I'm not going to pay you even if I have the money, I'm going straight for their fund and telling the court, compel this person that is holding their money to pay me their money and let me just go my way. So that's what Garnishee Proceedings is all about. In NOC and Ogini, for instance, the Court of Appeal decided that the judgment debtor can actually come to court and file an affidavit telling the court why they should not attach the money in their bank account. In NITEL and ICC, the Court of Appeal held that the judgment debtor is a mere spectator and an observer. So they cannot file such an affidavit. They can't come into the matter, that the matter is really just between the garnishee and the garnisher. So different decisions. Usually the garnisher should commence the garnishee proceedings in the state wherein the bank account is, and then it must be a sum that's attachable. So, and then it must be a sum that is present, that is currently being owned in or held in that bank account by the judgment debtor, or that falls due, for instance, a salary. So you cannot really garnishee expected earnings. No, it must be certain. It must be sure that, okay, this money the person owes it, this money is being held in this account, or this money comes into this account at so period, like a salary. So it's not we're not speculating. So that's what garnishee is. Garnishee is very technical in Nigeria, or let me say garnishee is very tricky in Nigeria these days, because sometimes the judgment debtor already preempts what the creditor can do. So they already liaise with these banks underneath, and then when the banks are when you file your motion asking the court to compel the bank to pay you, the bank comes to court because they need to come to court to show cause. They come to court usually, and then they tell the court that there's no money in their account, or there's a ridiculous, or maybe you're claiming 2 million naira. They could come to court and say that, oh my lord, this person only has 1,000 naira, 525 naira in their account with us. And so it's been found that in some instances, the banks collude with the judgment debtor to declare wrong sums, or unfounded, untrue sums, or to even have them surreptitiously move their monies out of the bank account, in anticipation of a garnishee proceeding against them. This is unethical, this is improper, and it defeats the purpose of judgment, because if judgment cannot be enforced, then the court has acted in vain, and the court does nothing in vain. So, but these are some of the realities that lawyers have encountered, while pursuing garnishee proceedings in Nigerian courts. How does garnishee proceedings work? So a garnisher will file a motion ex parte. That is, it does not need to put the bank on notice. The garnishee just files the motion ex parte, supporting it with an affidavit, stating what they know about the bank account, the sum that they suppose is in the bank account, the reasons why the court should make the order to attach the sum in the bank account, in settlement of the judgment sum owed to them as a judgment creditor, and so on and so forth. So when they file this, the court then sometimes also, a lawyer once mentioned that when he files his garnishee proceedings ex parte these days, the court compels him to put the other party on notice. And I've been in court and seen this myself. The lawyer, my senior in school, actually had filed ex parte, and then the court compelled him to put the banks on notice. The purpose of ex parte is to spring a surprise, so that before they can move the funds or lie about the actual sum, there's already a court order, and they cannot go against the order of the court. And if they lie to the court, it becomes very contemptuous and very, very dangerous. But when the court now compels the garnisher to put the garnishee on notice, now it might, because the contention of the court is that you cannot just spring a surprise and then put them on notice so that they would come, because sometimes they do not show up, and then the court says that you can't just make them do something without their knowledge. So put them on notice. Good rationale, bad rationale, up to the court. But now it works against the garnisher, in the sense that when you now put them on notice, you have given them adequate time to carry out whatever sinister or clandestine thing they want to do to frustrate, the enforcement of the judgment. But it is what it is. The garnisher will file a motion ex parte supported with an affidavit, or supported by an affidavit and a written address. So after that, the registrar will enter it in the proceedings book, and the garnisher will be heard by the court. When it's heard, the court will make a decree called a decree nisi. A decree nisi means it's not absolute. It's a semi-final, temporary decree, can be confirmed or can be cancelled. Just like in divorce, in this dissolution proceedings, the court first makes a decree nisi before it becomes absolute after 3 months, if there's no supervening factor or any other development. So after the decree nisi has been made, this decree nisi, usually called Form 26, is served on both the garnishee and the judgment debtor, that is the bank and the bank account owner who is owing a judgment sum. So the registrar will then fix a date for the garnishee to come to court to show cause. The garnishee has to come to court within 8 days to show cause. He has to file, that is the bank, they have to file an affidavit to show cause as to why the decree nisi should not be made or should be made absolute. So they could come to court to refute the claims, oh, this person does not have this bank account with us, or this person does not even have money in this bank account, or this is how much they have, it cannot even cover, or it can cover. Whatever it is, they have to say in their own defense or in agreement with the claim. of the garnisher, the garnishee will come to court within 8 days of service of the decree nisi to show cause, and based on whatever they say, of course, the judgment debtor would also be aware now, so they would also come to court. And this is where I talked about how they could file an affidavit, or they could just be a mere observer in the case. So the garnishee comes to court to agree with the decree nisi or to refute it and show cause why or why not the monies in the account being held by them for the judgment debtor should be attached or not, or even if there's no money in it or there's money in it, whatever they have to say, they come to court and they say it. And then afterwards, depending on how that proceeding goes, the court will decide if the decree nisi is to be made absolute or if it is to be cancelled altogether. The implication of a decree nisi, aside from drawing the garnishee to court and the judgment debtor, another implication is that it stays, the garnishee from paying out the money in the account to their customer, that is the judgment debtor, until the matter is decided for or against them. Whatever is in the account up until the time the decree nisi was made cannot be paid out. It must be there, maintained in the account until the court makes a decree absolute or cancels the decree nisi. So as in most cases, service is very fundamental. A decree nisi must be served on the garnishee. So this is not a clandestine procedure. Even though you come by way of motion ex parte, as soon as a decree nisi is made, it must be served on the judgment debtor and on the garnishee. They must know that the court is about to make an order compelling them to pay the money held in their account for their customer to you, the judgment creditor. They must know, so they must be served. And after they've been served, they can come to court to show cause why or why not the decree nisi should be made absolute. They have options too. Instead of coming to court, they could just straight away pay the money to the judgment creditor. Once the money has been paid, it terminates the proceeding, outright. But aside that, they can also come to court to show cause as to why they cannot or should not pay that money held for their customer to the judgment creditor. So in this instance, the court looks at the bank, that is the garnishee, as owing that money being held, owing it to their customer, the judgment debtor. So they can either pay the money. So if they pay the money to their customer, that is, if their customer withdraws the money, it's like they paying back the debt that they owe their customer. But in this case, the court is now asking them by a Garnishee proceeding, instead of paying it to their customer whom they also owe it to, their customer who also owes another person, pay it to this person that they owe them, and let everybody be happy. So that's basically what the Garnishee proceeding is about. The garnishee can also come to court and say, oh, this money, it doesn't belong to this person, even though it's in their account, or this money is already, there's a lien over it, so probably it cannot even be paid out even to the customer themselves, talk less of a judgment debtor. They can come to court and show cause why the money cannot be attached, and they can come to court and agree with the court or even pay the money once a decree nisi has been issued. So what if the court makes the decree absolute and the garnishee, the bank, does not pay the money? Then the money can then be attached by a writ of 5 fee. I talked about a writ of 5 fee in the video on judgment execution. Please watch the video. That's all I want to talk about in this video. I will see you in my very next video. Don't forget to subscribe to those.